You're listening to the Quint's podcast.
Eminent lawyer Prashant Bhushan posted 2 tweets criticizing the Supreme Court, for which he was held guilty of contempt of court. One said that the court had failed to ensure access to justice during the time of the pandemic, and the other said that the court had played a role in the destruction of democracy. Well, of course, the case ended up being one of the top highlights from the Supreme Court this year, but the questions at the heart of it, do they truly represent the state of the Indian judiciary in 2020? You're tuned in to The Big Story, the podcast where we dissect the headline-making news for you. And I'm your host, Shorbori. Hi everybody, this is one of our final episodes of The Big Story from this year, and it's that time of the year where we bring you the top highlights of 2020 from the courts and what essentially defines the judiciary this year. And in this podcast, I'm joined by one of our regular guests, Vakasha, Sachdev, the Quint's legal editor. Hey Vakasha. Welcome to our second last episode of this year.
I mean, and taken way too long for this year to end, but we finally got here. So,
and this was an undoubtedly different year for the judiciary as well, right? Which is so used to these cumbersome physical hearings, and they had to switch to a technocratic approach with video conference hearings. And of course, there have been some boo-boos on that front as well, with shirtless lawyers and face-back appearances.
I mean, that became actually a pretty big thing. I mean, there were so many of these cases where the courts had to actually start shouting in between and saying look, there has to be an SOP and a proper procedure for this, because people just didn't seem to get it. They were just like, theek hai, we can come in our banyans and all. And some of it is look, sometimes you have situations where it's basically a lawyer who's not actually supposed to argue. Who is just say the AOR or whatever. But the point is sometimes they actually will need to be called on for assistance. So it was really bad planning by all of them.
But anyway, CJI Bobde proudly said that the judiciary was resilient this year and that the Supreme Court wasn't even shut for a single day throughout the lockdown. But the question is, did it come through for democratic rights and civil liberties the way it was expected to? Because, initially we saw some speedy decisions by the apex court, like ordering decongestion of jails to keep inmates safe. But then that enterprising front sort of faded away, right?
Yeah, I think, the problem the problem with what happened was that when the crisis began, the court actually seemed to be very proactive about what it was doing. As the sort of coronavirus crisis itself had started to build up, the court very proactively said, okay, look, we'll have to shut down physical hearings, but you know what, we're going to make, so they first kept they kept physical hearings at limited benches for urgent matters. Then they brought in the video conferencing system, and they did that quite quickly. And this is not just the Supreme Court. I mean, if we look at some of the high courts, like the Delhi High Court has done a great job of this. The Bombay High Court, I mean, incredible stuff. Like in the Bombay High Court, you can actually you don't even, because at the end of the day, remember, these hearings in the courts are supposed to be open hearings, right? So the Bombay High Court took that very seriously, and they made sure they got a good video conferencing system with Cisco's WebEx and stuff. And they actually make sure that any person from the public can access those links, which not a lot of other people are doing. The Supreme Court, for instance, only gives the links to the people involved in the case, and the media also it's quite hard for them to get hold of it. The Delhi High Court makes sure media gets hold of it, but likewise. So, I mean, there were these kind of issues even at the start when the Supreme Court was being proactive about it. But then once you see, even that, then for instance, the decongestion of jails thing, a very, very important and notable point they made. But then the court itself starts to dig the holes that even within that. So within that same very, very good order, over the course of the hearings there, the court then set out a thing where they said, okay, look, so the criteria for deciding who's going to be out on parole or whatever should be they made the criteria based on the gravity of the offence, which in normal times makes a certain degree of sense. But when you're dealing with situations like COVID, where there's a health crisis, especially for people above 60, especially for people with comorbidities, they were almost, by not keeping that as the focus of it, it ended up seeing so many, a lot of people, including political prisoners, remaining in jail.
Bhima Koregaon case especially.
Yeah. I mean, so all those people there, except for Mahesh Raut, they're all older people. They're all at-risk people. All of them have comorbidities. Most of them are above 60. I mean, it was really, really tragic, and you saw the consequences with Varavara Rao ending up,
Yeah.
in the absolutely terrible state he was in the government hospital also there, and then finally only later being shifted,
Right.
and he had COVID. I mean, and that speaks to, I think, a bigger problem with the way we're looking at the criminal justice system in India. And the Supreme Court ideally should be playing a leading role in trying to combat that and make it more humane and make it more responsive and careful about what it's doing. But it's almost like, even when they have the good intentions, they didn't really follow up on that and take it forward in the way they should have.
Even in the migrant exodus crisis, the Supreme Court practically accepted the centre's fake news narrative about the whole thing, and then they didn't even prioritize on important cases that were still pending pertaining to human rights abuses.
No, I mean, and that was, I think, the migrants crisis was the most important thing the court has had to hear in a long time, because what essentially happened there was that a policy decision was taken by the government, which it was well within its rights to do, right, in terms of putting the lockdown and etc. and all that. But when a government does that, there have to be considerations of the consequences of what's going to happen, and the migrant crisis was something which should have been foreseen by them anyway, right? And then once it starts happening, also actions need to be taken. But instead, the government first kept denying it. They said there was no problem. They said they've taken steps even though they hadn't. And then to go up to the Supreme Court and tell them there are no migrants on the roads, when we all knew that was not true, and it was there for anyone to see, and the court didn't even bother questioning it. And then, as you said, the narrative that the only reason the migrants are on the road is because of fake news being spread, which was absolutely nonsensical, given that these are people who are living day to day. If they don't have the money coming in from their jobs, how are they going to stay where they were? How are they going to feed themselves? Obviously, they were going to go home, right? So the problem was that the court didn't have to make, it wasn't very difficult things which it had to do. It just literally had to ask certain questions, and it just kind of failed to do that. And it was very, very strange to see that. And obviously 2 months later, things had got so bad, when we had like things like the Aurangabad situation where the migrants died on the tracks. And I mean, then finally the court wakes up. But I mean, think of what it could have achieved in the 2 months where it was just accepting whatever the government was saying and refusing to accept petitions, and not just refusing to accept petitions, casting aspersions on on the kind of lawyers who are coming up and filing these things, because we all know that there are a lot of people who just file PILs all the time, but there were some very, very genuine, heartfelt requests for the court to help out, which were first denigrated by the Solicitor General, and then the court just kind of bought into those narratives a lot of the time, and that was quite unfortunate, actually. And I think that's its failure to sort of ask the right questions and take urgent action on the migrant issue is something which will be a lasting legacy of the court, because you've had over the last few years these questions raised, but is the court standing up to the executive? Is it doing its job of being a check and balance, of conducting judicial review?
And what was really odd was how the Supreme Court picked up the contempt proceedings against Prashant Bhushan with so much urgency. Yeah. That perhaps became one of the biggest highlights for me from the Supreme Court this year. Not just because of how it all concluded. That was also really interesting, the way it all unfolded, but the kind of questions that it ended up raising about the judiciary, right?
Yeah, and I think, and in that sense, it actually was very well in keeping with things even before lockdown. Because if we look at what was the situation before lockdown, from December itself last year, right, 2019 December, when you had the CAA stuff come up, people rushed to the Supreme Court to ask for what? They asked for protection for students against police brutality. They asked for, some sort of protections for people who are actually out there protesting. And the court declined to take any action then. You come up to January, petitions now, multiple constitutional law petitions have been filed. The court sets a date for 4 weeks from then in February for the hearings, and then just ignores it. They just ignore hearing those kind of cases which were so urgent. Or, in the beginning of the year, January 2020, you have the order come out in the Anuradha Bhasin case, which is on the Kashmir restrictions. And the court finds that the way internet shutdowns and restrictions were being imposed in J&K didn't seem to be correct. It wasn't following the right procedure, and directs the government to then, follow the right procedure. But again, it's like there was a situation already with that judgment where there was a lack of follow-up, right? Where even though it's finding that things were done wrongly, it didn't actually hold anyone to account. It didn't, impose any sanctions, anything of that sort. So even though it then set up told the government to follow a particular set of procedures for the restrictions going forward, the government is just following a form at this point, right? Like they're not really asking the questions which the court was supposed to be asking, which it delegated to the executive, which is, I mean, didn't make a lot of sense. Like, I don't know if you saw the second Anuradha Bhasin judgment when there was a whole thing that, okay, look, during the pandemic, especially people need 4G internet, right? Because not everyone has a broadband connection. People are going to be trying to access whether it's health information, whether it's education, whether it's your jobs. You need the internet to be able to work, especially in a pandemic. And for Jammu and Kashmir, most of it, like I think now 2 districts have 4G internet. Everyone else doesn't. It's insane because, I mean, look at what we've all survived on having the internet during this year. Just think about how difficult it's been for people to not have that. And the court, these are questions the court could very well ask because it's a matter of proportionality. That is one of the issues which comes when you're looking at constitutionality of state actions. Whether something is fitting in within Article 21, the right to life and personal liberty, and whether it's a reasonable restriction on free speech and on the right to profession. And the court just delegated those questions and didn't, they didn't ask the questions themselves. And I think that failure to do that, failure to list things with urgency, as we saw with the CAA, with electoral bonds, still nobody knows what's happening there. And perhaps the worst is with habeas corpus cases. Mehbooba Mufti's habeas corpus petition was filed in February, after we finally got a PSA dossier and a detention order against her. The court just sat on it for months till finally the government themselves after 6 months is like, you know what, okay, fine, we'll let her go. And so, by failing to do these things on time, you're just making government actions constantly a fait accompli. And in the meanwhile, you're then hearing, as you said, like things like the Prashant Bhushan case, which really was not that important. Like Bhushan put out 2 tweets and suddenly the Supreme Court's authority and independence is under threat. I mean, look, regardless of what the court again finds in that case, it may well find that those tweets, and it did, it found those tweets to be contemptuous, and that's something we have to keep in mind. But is that really the most urgent thing which the court has to deal with when it's coming to justice in this year of all years?
And there have been a bunch of just wasted opportunities where it really looked like the Supreme Court would come through, but then they didn't. In the Sudarshan News case on the UPSC Jihad segment, where the Supreme Court made some really interesting observations on how to regulate hate speech, whether or not that should be a government-functioned regulatory body. But then, by the end of it, the Supreme Court didn't really come through.
And that is a big disappointment because, we've seen this now. There's been 3 good opportunities to provide a ruling on hate speech. And this is an issue, it's a major issue which we're facing in the country at this point, especially hate speech through the media, like through mainstream TV channels. And Sudarshan News was a great opportunity because it was so blatant, the language being used there, the terminology being used there, that even the central government in its eventual order has said that there were violations of the program code, even though it's not taken any, it said, we just cautioned them. But even they found that to be the case, right? Now the Supreme Court initially starts by, in September, it puts a stay on further broadcast of the episodes. It's asking all the right questions about hate speech and what the regulation should be. And then the central government comes in and just kind of obfuscates it by saying, actually, if we want to regulate, let's first regulate digital media, which has nothing to do with the issue at hand, right? And then, but the worst part was that the central government said, okay, look, no, don't worry. We are here. We are already conducting the proceedings under the existing rules into this. So you guys don't need to take a call on this right now. And you know what? Fine. Let them take action. For over a month and a half, they kind of stalled what was happening there at the court through just this measure. And then once you've now seen that they've passed this order and they've done nothing, and the court is still not being able to take any action. It was such a good opportunity when the court had shown the right thing. And even before the Sudarshan thing had been filed, another case had been filed much before in the Supreme Court arguing about the fact that the way that Tablighi Jamaat was victimized was a clear violation was hate speech, and was a violation of program codes. It was a violation, and they actually alleged also that there were IPC offenses involved in the way that was done, in terms of spreading community hatred. Now, we've seen a few months down the line how every single court case against the Tablighi Jamaat members has fallen apart, and they've been acquitted, they've been discharged. The courts have specifically said that the police never had any evidence against them. There was no evidence that they violated the law. For the ones who are foreigners, that they violated their visa conditions. It's become very clear how much of a stitch up that was. And this petition has been with the Supreme Court for months. First, it just would not list it. When eventually it started listing it, there now the Supreme Court itself is holding up the central government multiple times saying your affidavit is not good enough, you've not addressed the questions, you've not addressed anything. But they just keep giving them more time. They keep saying, oh, this affidavit is not okay, take another 3 weeks to file a new one. This affidavit is not okay, take another 4 weeks to file a new one. I mean, what is the point of this? You either take, you've got the affidavit, rule on the basis of that and say, yes, the central government has not taken steps enough and therefore action needs to be taken. It's just very strange seeing this court, which is the most powerful court in the world. It is the most powerful court in the world in terms of the kind of jurisdiction it has, in terms of the kind of powers it has, and it is just not holding anyone accountable for those who actually hold power and who are responsible for things or who could do things. It's not even about saying that, okay, this is the government's fault, right, that hate speech is being done. It's saying the government needs to take action against those who are committing hate speech. That's it. And that's all the court needs to do here. And they're just not taking those steps, even though they're having opportunity after opportunity after opportunity to do so. We saw again, now there was the Amish Devgan case where the court has given a lot of very nice statements about hate speech. But again, there's no practical steps taken at the end of the day. So, the court, I think, is going to have to ask itself, that you had all these opportunities. Why was things not done? Why did you just accept government narratives? Why did you, rush through cases like Prashant Bhushan's and not other matters?
The more we talk about the Supreme Court, it feels like 2020 was the year of high courts, right? While obviously many people were expecting for the Supreme Court to step in at a time of this crisis. But interestingly, it was the high courts that were rather proactive in standing up for civil liberties, right? There are many instances. In fact, the Delhi High Court, for instance, granted bail to several people who were arrested over the Delhi police's conspiracy angle in the Delhi riots. Allahabad High Court, in fact, had a remarkable year. They wrapped the Uttar Pradesh government for those controversial name and shame banners that violated citizens' privacies. And so what are the top moments for you from the high courts this year?
I think the Allahabad High Court especially deserves a lot of props because at the end of the day, remember, they're working in a state which doesn't, if you look at the kind of laws brought in, whether it was that name and shame banner thing first being done as a policy, now they've actually brought in an ordinance to make that happen, right? You look at the love jihad law they brought in. I mean, I'm not going to dignify it by calling it a conversion law. It is a dog whistle law. It is meant to be something which is meant to create harassment for interfaith couples. It is meant to stop that from happening. It is meant to target the Muslim community. It is meant to target women's agencies. So we're not going to call it a conversion law because that isn't what it is. Now, if you look at the way there's a lot. It's very difficult for the Allahabad High Court. I think. I mean, they have so many of these cases to deal with, and yet they've passed some very, very good orders. Whether it was during the CAA times granting bail to people, whether it was the Kafil Khan detention order. If you read that, the order of the court there was fantastic, where it released him because he'd been held under the National Security Act in a form of preventive detention for months. And it was on the basis of a speech where he's urging harmony, he's urging non-violence, he's urging all of these things. Just he has some not very flattering comments to make about Amit Shah and the CA. And on that basis, he was being, the local magistrate had said, oh no, my God, he's a threat to security of the area and this and that and all these kind of things. And he had already been granted bail for the same speech because, again, the police had immediately filed a case against him. The court had granted him bail because it was a joke of a case to file against a person. And then to get around that, they filed an NSA order against him and said, oh no, now we have to preventively keep him in detention. And unfortunately, the unfortunate thing about the system is, even though the court eventually passed a good order and let him out, he still spent months in jail as a result. But then the Allahabad High Court comes out and, it's a fantastic judgment because it very clearly goes through the speech. It reproduces the whole thing, shows you exactly what is said, exactly how it doesn't meet these kind of things which the government was saying or the police was saying. And then it orders his immediate release. This is what a constitutional court is meant to do. Because what happens is, a lot of the times the courts think that they seem to have to show a lot of deference to the executive because, security is at the end of the day a prerogative of the government, right, or of the police. They're the ones who are supposed to know better. But even if they do know better, if they're not following the right processes, if they're not doing the right, if they're not, if they've not got the right paperwork, these are also very valid grounds to have a person released. Because if you don't do that, you're just destroying the rule of law, and there's no point having a country which has great ambitions of things if it doesn't have the rule of law. And so the Allahabad High Court really stood up for that time and time again this year. As you said, the name and shame banners thing, again, with urgency they heard it, and they then passed a solid, strong order. Again, unfortunately, the Supreme Court allowed a ridiculous appeal against it, and not just the appeal, they agreed to a reference to a higher bench with for no reason. There was no question, there was no issue of law involved there. And the Supreme Court somehow just accepted the UP government argument and let it happen. When this whole love jihad frenzy was being created, one of the things which the UP government tried to cite was a single judge bench of the Allahabad High Court, which had made an observation where it said that, oh, if a conversion is done purely for the sake of marriage, that would not be a valid conversion. Now, it was a very strange comment to pass, because that case wasn't even about validity of the marriage or validity of the conversion. It was about an interfaith couple asking for the court to protect it from the police and from local goons and from the families of the couple. That was what the case was about. Now, the thing is, sometimes what happens is, especially because single judge benches are like short-term matters, they're heard very quickly. There isn't a lot of thought about the constitutional implications sometimes involved. And this has happened previously at the Allahabad High Court as well. But then, and this was then latched onto with great pomp and alacrity by the UP government, saying, "Oh, look, see, even the Allahabad High Court is saying that this is an issue, and therefore we need our anti-conversion law." But they conveniently ignored the fact that even before that, well before they brought in their law, the Allahabad High Court had already also said, you know what, a division bench, which is 2 judges, overruled that single judge bench decision and said, no, that is completely wrong. At the end of the day, people have a right to privacy, they have a right to practice a religion of their choice as long as they're adults. And there is no question of coercion or no question of being forced to do something. You're entitled to do what you want. Like if I want to convert purely for the sake of marriage, just because that will make it easier for me to get married to someone, which we know is the case, right? Because the Special Marriage Act creates a lot of difficulties because it has a 30-day notice period. So I may say that I want to convert to Islam or convert to Hinduism or convert to Christianity or whatever it is, just to get an easier marriage done. And that's purely my business, because religion is a personal, private matter. It's not a matter for the community. It's not a matter for society. It's not a matter for the state at all to get into. And they've passed a slew of excellent judgments on this over the last month or two, like a number of orders on interfaith marriage questions, because we know in India how everyone loves to interfere. The Karnataka High Court again passed good orders on CA stuff. If you remember Mangalore, it was very controversial because we saw videos from Mangalore of how the police was sort of just firing into the crowd. And the thing was, they arrested like some 20 plus people and put them in jail and were invoking very, very strong, sedition and waging war against the state and all that, these kind of, claims against them. And the Karnataka High Court said, you know what, this is rubbish. There's, you don't have any evidence for it. You don't have video proof. You don't have statements. You don't have eyewitnesses. You've just randomly picked up people from this area, said they're connected to PFI, which is not a banned organization. Again, we've heard PFI as a thing constantly throughout the year. It is not a banned organization. It is not a terrorist organization. The government can designate it as such anytime it wants. It has not done so. So just then saying PFI was all that was done in that case. And so the Karnataka High Court said there is no grounds to, put these people in jail. At the very least, they have to be granted bail, and, you want to take them to trial later when you have evidence, kar lo. That's basically what they said. And again, the Supreme Court comes and just puts a stay order on that bail order. This is back in March, without providing any reasons. Now, if they'd given some reasons, said, oh, look, the state has provided information which clearly shows that, there is more to it, there is a need to have them in custodial interrogation, okay, fine, you can understand that, right? It passes no reasons for the order. No affidavit was submitted by the central government or by the state government saying that, or the NIA or anyone saying why this had to be done. And then 6 months down the line in September, the court is like, actually just let them go. Again, without saying, has there been a material change in circumstances? Has there been a thing? So it was a shocking thing where you saw the High Court really stepping up and then the Supreme Court almost ruining the whole thing. And the Karnataka High Court has also done that in other matters. There was a thing where, again, something which may seem just a formality, like in Bangalore last year, the government imposed Section 144 to stop protests from happening. And they said it's going to be in place for a month. It's going to be in place for XYZ amount of time across the whole city. And this is something which happened across the country, right? And the Karnataka High Court said, look, you cannot do this. When it comes to an imposition of Section 144, it has to be done district by district. There have to be reasons in writing specifically why it is required, what is the need. It has to be times bound. You can't just have these blanket things lasting forever. And, very, very solid, well reasoned, well thought out order. And it's something which hopefully we'll see more high courts around the country learn to look at, because that's something that high courts can do. And sure, sometimes when these things go up on appeal, there'll be stays, there'll be problems when it goes to the Supreme Court. But the High Court itself can pass some fantastic judgments because they have a lot of powers. They are meant to be the first line of constitutional defense for a citizen, is your High Court, rather than the Supreme Court, And the High Courts this year showed that they still have that relevance to it, and that they can and they are willing to stand up even to the government if required to do that. Madras High Court did the same thing. Madras High Court passed another great judgment this year. I mean, it's an interim order at this point. But for instance, like Arogya Setu, when it was rolled out, was being suddenly touted as, it was becoming the next Aadhaar, was being said, oh, this mandatory for this, oh, it's mandatory for that, oh, it's mandatory for this. A case was filed in the Madras High Court against this. And because, for flights, for train bookings, for a lot of government things, the government was making it mandatory. Private services are making it mandatory for a number of things. And the High Court there again said, look, we are still going to hear the detailed arguments, sure, but at this point, they made sure they passed an interim order saying, no, it cannot be made mandatory for these things. Because there's clear issues of, again, privacy and which again, people like to ignore because they think that, oh, it's just an elitist concern, but it's not. Because once that data goes, and once that data goes away for everyone, whether it's a rich person, poor person, whoever, that data, the way it can be used and manipulated against even the poorest of the poor, is not something which we should be willing to accept, or accept lightly at any rate. And the Madras High Court again stood up for it. The Bombay High Court has again passed important orders, especially on, for instance, some of these issues of the way the kind of media coverage over the Riya Chakrabarti and the Sushant Singh Rajput case went. They've again passed some orders there for protection of people, of some of these actresses and stuff. So, the High Courts have done their bit. It's just, one could just hope that the Supreme Court would also start taking up cases with urgency and then just asking the right questions.
So now the hybrid functioning of the Supreme Court, and generally the judiciary is here to stay, and CJ Bobde had said that there's no looking back from here. But what are the gaps that the judiciary has to fill in? What does it need to do better in the coming year, you think?
I mean, see, the thing is, there is a great opportunity here with, this new hybrid functioning and video conferencing as a way to, it could actually be in the long run a way to make a lot of things easier in terms of, because say, for instance, I need to go to the Allahabad High Court right now. Now, I live, say, in Noida. It's actually closer for me to go to Delhi than it is to go to Allahabad, right? The difficulties in traveling, etc., which many people end up spending so much money on just having to, for their cases, having to travel and go and reach a court which is far away. Those costs can all come down now with usage of things like video conferencing. So that does create a potential for it to be a great leveler. At the same time, the infrastructure required for it is not available with everyone. Not every lawyer is going to have the best internet connection. Because remember, we're not only talking about the big shot senior advocates. The legal profession is about a lot of small scale lawyers who will work for the poorest of the people, for local courts. Now, for all of them, the infrastructure may not exist. It's not even a question of whether they are able to buy it or not. In smaller towns or in villages or in smaller areas, you may not have the infrastructure in place which will actually allow you to properly use video conferencing, right? So these are issues which are going to crop up over time as it goes along. And the courts have to really think about how they're going to create a leveling field for it. So when they're going to now, if they're going to bring in video conferencing and this kind of remote working as an option for the courts, they have to ensure that there is a leveling of the playing field so that smaller scale advocates and areas in smaller towns and smaller courts are able to still function without being disadvantaged. Because so much of what is justice is what has to happen in those spheres, right? In the small district court, in the magistrate's court, for someone who doesn't have the money to afford the big lawyer but has got like a lawyer who's willing to work hard but is just not in the big time in Delhi. Those people also have to be able to do their jobs, and so the court has to look at things to do that, because there's been a lot of problems. A lot of smaller lawyers have suffered a lot over the course of this year. A lot of the smaller courts have not really been able to function, and a lot of cases have just been pushed, whether it's in property disputes or even domestic violence issues, or things which family matters, like we say divorce or things which you couldn't really take up because you were trying to deal with more urgent things. Now these all create exist, they do create problems which are serious and urgent as well, but have just been kind of put on the back burner for a little bit. Now those kind of things have to change. Now we've already seen courts taking up more and more kinds of cases. Some courts have already started, conducting physical hearings again. So there has to be, I think, what the court needs to do here is sit down and strategize how to make this work going forward, how to get the best out of this. So they need to sit down with leaders of the bar, with members of the bar from all strata of it, not just the big guys and the big, the big senior advocates. They need to sit down with representatives for all layers and strata of lawyers throughout the country. Look at the courts, talk to all the lower courts as well about how they've been functioning, what are the challenges they're facing, and then try to come up with a detailed plan for how to make this hybrid system work, because the opportunities are exciting. The potential is there for this to be a way to really take it forward. You won't have physical overburdening of courts. I mean, there are times when you go to one of the courts, and it's so overcrowded, everyone's packed in together, the infrastructure is crumbling because of that. You can have an opportunity to really address all of these things if you keep in mind issues of access, issues of saying that, okay, look, if we're going to do this, we have to have a functioning center where lawyers who don't have good infrastructure can go and argue their cases, in one of our own facilities, in a local area where that can work. So, those kind of questions have to be asked and worked on. And if we do that, I think we could see even finally this may hopefully start spurring on even the thing to have live streaming of cases. We know this was something the court ordered 2 years ago now, and it's still not happened. To have cases, the Supreme Court to have its cases live streamed. Now, the fact that it's been able to embrace technology this quickly now shows that these kind of things can be done. So I think as long as there is a full consideration of the tougher questions involved in this, I think we could see some very, very exciting things going forward.
Okay, so that's a wrap for this episode. Thanks a lot, Vakasha, for joining me.
I'll just say thank you to all our readers and all our listeners for for keeping on watching and listening and supporting us throughout all of this time. And at the end of the day, we are doing this for you guys. So seeing that people have been wanting to actually understand all of this and engage with all of this information, even things which might seem technical and arcane, has been great for us, and it's something which we'll hopefully be able to keep bringing you more and more great information and important explainers and news and analysis and everything in 2021 as well.
And for our listeners, you can also check out the legal stories that we worked on this year on the Quint website. If you like listening to this episode, please subscribe to the Big Story playlist for episodic updates. We're live on Apple, Google Podcast, Spotify, JioSaavn, and most of the other popular podcast streaming platforms. For other podcasts, please log on to the Quint website and check out the podcast section. For any feedback, shoot an email to podcasts@thequint.com.
Thanks for listening. Log on to the Quint's website and check out our other podcasts.